In an interview with Claims Journal, Kathy Padalino of Chubb discusses EPL losses, social media, and the costs associated with these type of claims.
There's no doubt that the economy has attributed to an increase in claims. Employers are trying to navigate through a tough economy. They're not hiring new employees, and in fact, they're obviously laying people off. The unemployment rates are sticking at double digits, and we don't anticipate that they're going to go down significantly. And what happens from a claims standpoint is that aggrieved individual is going to bring a claim. And in years past, where we saw a charge that might be mitigated or settled out rather quickly because that person went on and found another job. They were happier in their new job, and in fact, many times they were paid more in their new job. Well, now that job is so hard to come by. They can't find the next job, and if they do find a job, they're not making the same amount of money or perhaps don't have the same opportunity they had in their whole job. So they're fighting and holding on to those claims. Those claims are going to trial a lot more. We're seeing a lot more single plaintiff cases, for example, stretch out and go to trial, whereas in the past they might have again been settled out, mitigated, or again the person may have just said, you know what, I'm happier in my newer position. And certainly the economy, leads to not just the lengthening of the case, but the severity of the case. And all of those factors tie into an interest from a plaintiff attorney side that the damages are going to be higher, and then there's heightened interest in the lawyers taking the cases as well. Social media is such a hot topic in the employment arena. It doesn't all tie to insurance per se, because there's productivity issues or copyright issues, invasion of privacy issues, which can lead to employment suits. But where we see a real exposure and something that the employers are navigating through today is the issue, for example, of using it as a recruiting tool or a hiring tool. So as, for example, a profile picture is now evident on a Facebook, for example, or a video resume comes across the desk. Years past, there was no way to determine, for example, the sex or race of that person. And now, if that person is not hired, they have an additional basis to bring a claim of perhaps discrimination. The other area that we're seeing some additional interest is the concept of the National Labor Relations Board has come out with some guidance with respect to concerted activity. Whether you're union or not union, you have every right in the workplace to effectively complain about your workplace conditions without fear of retaliation. Now, using social media, for example, has heightened that exposure. Again, whether you're union or non-union, that law protects you, and it's something that they're really looking at closely. And we're looking at social media policies as an example, and really looking at the exposure. Another last, I would say, heightened exposure is just the disparate treatment of individuals. You looked at this Facebook page for me because I'm of a certain protected class, for example. You don't look at everybody's Facebook page, and sort of that disparate treatment with respect to the enforcement of social media policies is something that we're going to be keeping our eye on.